Is that boring?
Right. No, it's a legal show.
Oh, yeah.
It's supposed to be boring.
Why am I bored?
It'll have legal topics.
Yeah, it's supposed to be boring.
All right, everyone. Welcome to the next edition of Counsel Table. We're here with a dear friend, former classmate from law school, Chaz Clays. Chaz, welcome to the show. Thanks for being here.
Thank you all for having me. I'm really excited to be here today.
Yeah, so I know we were kind of going over what we want to talk about with you, but just give us a little background about yourself. Where are you working these days?
Yeah, sure. So I am currently the Houston managing partner of a national firm, Weinberg, Wheeler, Hudgens, Gunn, and Dial, that's based out of Atlanta. We've got offices all over the country. Been there since June of last year. Prior to that, I spent the bulk majority of my career at a local firm, Texas-based firm, defense firm, which was, when I left, Donato Brown, Poole, and Molman. Before that, it was Donato Minks, Brown, and Poole.
You were with Donato's firm for how many years?
Jeez, it was, I'm dating myself. We're all getting old now, but it was probably 10 to 12 years. And I'd had a couple spots before that, but that was kind of the bulk majority of my career and where it had been.
Well, on our earlier show, we talked about how I still consider myself a younger lawyer. And then I realized we're not quite younger lawyers. And we were first year at South Texas together, and then you transferred out. But so your majority of time has been defense work, right?
Yeah, I mean, I'd say I've spent 85% of my career doing defense work. I've also had the privilege to do a lot of subrogation work as well for carriers on large loss property damage claims. So I get to be a plaintiff's lawyer, but just for property stuff. So that's a good experience. I think that experience helps both in your defense practice because it sharpens your knives on what a plaintiff should do and so forth. But yeah, I'd say the bulk majority of my career is a defense lawyer.
Yeah, and I know you were very loyal with Donato, and I guess an opportunity came up about a little bit last year before June.
Yeah, so I mean, I was Donato and them, the great mentor, still a great friend. Think nothing but the world of them. It had to be, as people asked me, as my team, my actual whole team up and moved with me. I had 17 folks decide overnight in about a 48-hour period that they were going to move with me. And it took a lot to convince them, and it had to be a special opportunity. And I was not going to just jump ship to go, one Texas defense firm to the other Texas defense firm. I felt like this firm aligned with a great opportunity to start something, wasn't in Texas, make an imprint in Texas, had a lot of business relationships that were the same, had a lot of mutual friends that were the same, had a vision and a practice emphasis that aligned. And I, talking with my wife, that I decided, this is what I got to do. I mean, and I haven't looked back, and I could not be happier. It's, I love the Donato guys. They're wonderful, but this was an opportunity that I couldn't pass up.
Are you the sole Texas presence for Weinberg Wheeler?
So there's Houston office, but we handle cases all over. We have 10 lawyers currently and about 15 staff, and we're looking to grow.
Oh, well, is Houston the only office?
Yes. Houston's the only office.
And is it mostly PI stuff?
So our practice across the firm is about 50% PI stuff, and then we have a monster construction, like a true construction practice, commercial litigation as well. My practice is primarily the PI based and or construction PI based, energy PI based, but across the board, the firm has a more in-depth practice where PI is not the bulk majority.
And so tell us what it's like. You kind of went from a firm where you just got to do trials, work up your cases, and go from there to basically being an office manager, or not an office manager, but managing partner, where you had to manage the entire office, right?
Yeah, so I mean, it's forced me to have to delegate a lot, delegate a little bit more than I'm used to. I mean, certain days you're working on leases, certain days you're dealing with making sure vendors get paid, and we have a fantastic staff in our office in Atlanta that handles the good majority of the day-to-day, but then you've got to deal with, so-and-so hurt my feelings, or so-and-so's got a bigger office than I do. And, and I kind of say that in joke, but there's just day-to-day stuff that you have to deal with, and, kind of just managing the folks in the sense of, hey man, you had a slow month work-wise, what happened this month? And, 99% of the time it's, oh, I forgot to get my time in, or, oh, I was on vacation and didn't do the vacation code. But there's just a lot that goes into it. And I really like to jump in and dive into my cases. I try a lot of cases. And, that's been very difficult for me to have to give up some of the bigger depots, the bigger hearings, but just got to do it.
How many offices do y'all have?
We're seven. So we
And
have,
it's a managing partner in each one. Their responsibilities, their client maintenance, training, mentoring, everything else. And how are y'all built from an administration standpoint, management level? Did y'all all participate together, or is there a management committee in Atlanta?
so we have a management committee that is made up of multiple partners from different offices. And so it's kind of a management at a broad strokes level. There's a management committee. And then within the management committee, there's an executive committee that kind of handles the day-to-day issues, whereas the management committee, or we call it the board of managers, they have a bigger oversight.
Is expansion on the agenda at your firm?
We want to grow where it's right. That's luckily that's kind of outside of my bailiwick right now. The Houston expansion has been fantastic, but look, we're always looking to, we want to expand organically. We're always looking to get new lawyers, new blood, and obviously expand our client base and our practice areas. And that's one reason why I like it. If there's a field of interest or a topic of interest, they say go learn, go see what we can do to develop that business.
Fabulous place. I met David Dow a couple times on some cases. We had an MDL down here, and I had some other cases. I know he's a peer of Daryl Barger, and he's a classmate of, he owns a hotel downtown, Don Jackson.
Yes.
And I met him through Don Jackson at mediation. And
yeah, in fact, I think Dave is some of Don's kid's godfather, and Don's
Baylor
son
guys
Dave,
or something.
Dave's kid's godfather. So yeah.
And I thought his approach was smart because I could tell, because I know how people do stuff, because I was part of my old firm, and there's a difference between expanding wisely with skilled folks that are consistent with the brand and opening up franchises. And that's not what y'all are doing.
No, we're not opening franchises. And I see it so
and that's
much.
not to be disrespectful of those that do, but the reality is some firms just open franchises.
Agreed. And, I kind of take the mindset of grow with purpose, find the right people. I've been interviewing people, and, I want to, it's the same with hiring new lawyers, right? You want to find the lawyers that are the right fit, right? They may look good on paper, but if they're not the right fit for your practice, then it's not what you want to do, right? I mean, you may have a lawyer that looks good, has tried cases, taken a ton of depots, but they run a small car wreck docket, right? Versus somebody that handles big catastrophic fatalities, big excess cases, and so forth. That's maybe not the right fit. And you don't want to just put a, square hole, round peg type situation. You want to find the right fit to grow. I mean, heck, I've seen on so many of these cases lately, you see defense firms, I'm like, man, I've never even heard of it. You look them up, and there's some, San Diego-based firm with 57 offices, or, a Colorado firm with 26 offices that are just there, and there's maybe one person in the office, but they can say they've got an office in this city, that city, and so forth. So,
and y'all are trying to stay away from that.
oh, from my perspective, yes, yeah.
Yeah, there's growth to grow, and then there's growth where you can have a meaningful output for your clients.
Yes.
And that, because I'm sure that Weinberg Wheeler was asked by clients, hey, we got a ton of stuff in Houston. We need some Houston folks. And they wanted Houston trial folks. And you're in a fraternity that's very small, by the way. I think you know that. You're probably too proud to admit that, but it's a reality of Houston lawyers between the age of 35 and 55 that have first chaired 20 cases. Real cases, not car wrecks. And not to say car wrecks aren't real cases. That was disrespectful, because I'll try those cases too, and I have to. But, that trial lawyer kind of nomenclature is just not what it used to be.
Yeah, no, I mean, and I think that's a virtue of, look, it's so hard and inexpensive to get cases to trial at this point, right? Courts are just not trying cases as much as they used to be. I mean, it's hard to get them. I've been blessed by having an opportunity to go and try that many big cases at this point in my career, and it's been fun. But I appreciate that and understand that, because it's tough.
And not to invade any confidences, but was this a headhunter deal, or is this a back channel? Hey, I know so-and-so knows so-and-so. You need to meet them because they need a Houston trial lawyer and you're a Houston trial lawyer?
Yeah, so it was definitely not a headhunter deal. And like I said, it was I was not even looking to move. It was kind of some mutual friends of the firm and myself, and just said, hey, these guys are looking. And, you hear it from multiple folks and, kind of gives you the push and, have a call, have a discussion, and then boom, it just happened. It just happened kind of overnight, just a couple months of talking, and then got super serious and boom. So.
Well, when it works, it's perfect because then you find someone on the administrative side, the anchor side of I'm in a geographic region my clients need to have lawyers at. I've got a lawyer that's really good. I've got a lawyer that can get some symbiosis because maybe we'll get a national rate structure. And that's an everybody wins scenario when it works out.
Exactly. And the firm was lucky. I mean, the firm had done a lot of work in Texas. They already had Texas lawyers, and they would either, affiliate in locally, or a lot of clients are like, no, we want the Weinberg firm to, handle stuff. So they'd bring them in and hire local counsel or whatever. So it was really a perfect fit.
That's great. I mean, I guess that it's never easy to make that change. So, did you have to go through a big process, or did they just put the right things on the table and it was time?
It was one of those things that it made sense from the day one when we started talking. It just seemed like it aligned. I was at a point in my life, I've got 2 small children, that this opportunity, it just presented itself, and it was the right fit. It just made sense.
It works when a national firm is motivated to have a geographical region with someone, they will do whatever they can do to make it work. So there's a benefit to that. Being
awesome.
the wanted is a good thing.
It is. And, I laugh when you said headhunter because I was trying to think. I've worked at 3 firms. I don't think I've ever had to put a resume forward.
This is my 4th firm I've worked at, and never once have I had to put a headhunter out.
A lesson to our younger audience that's watching: don't get lazy and hire headhunter with a firm that has to pay 20 points on top of your salary that's guaranteed.
I think it's more than that,
or 30 points, when 30. You can actually ask around town and find out who's hiring.
Well, and it goes to show you if you go out, you go to lunches, you go to the coffees that you're invited to, your network kind of expands, and all of a sudden you're being reached out to when you're not looking for a position, and a phenomenal position lands in your lap.
Well, and also, I mean, to the younger lawyers out there, just don't be an ass, right? I mean, behave yourself in depositions, behave yourself at court. People take notice. I've been in court and seen people argue and thought, man, that's a good guy. Or been in depots like, hey, this is an up-and-comer. But, no one wants, not no one, some people do. They have jobs, but from my perspective, I don't want to add somebody to my team that can't get along with folks. You don't want to do it. You don't want somebody that fights on everything. I mean,
this is a PG-13 show, so you can say no asshole rule. That's okay.
Fair enough.
Law school Chaz is much different than practicing Chaz.
Yeah, I've matured a lot since then. So I've watched. I had to study up on this show before, and so over the lunch hour, I was watching the interview with Shane y'all did, and
you didn't have much to study because we've only dropped 1 episode.
I know, so but
He's up to date.
I laughed looking at it about Shane was like, man, I hate the people that just object to stuff to just generate, as you said, you generate a 0.8 objecting the first time, and then generate another 0.8 when they go back and supplement it, right? And that stuff infuriates me. I mean, just. This job is hard enough, right? And it's harder when you have people who make your job hard and make your life difficult. You're going to practice with a purpose is what I want to say.
And, it's to go into actual practice points, Chaz came in on a case that I was on, and I was working with another firm, and then the defense lawyer called me and he said, hey man, I hate to do this, but we're going to have a new lawyer jump in on this case. I'm going to get out. So, if you oppose it, what's going to happen? I was like, who's the lawyer? He said, Chaz Clays. I couldn't help but hide my smile and just say, perfect. And now I know this case will be able to move forward in an easy fashion. We took depositions by agreement. We picked up the phone. We texted. We had lunch together to talk about the case, and case got resolved. And it was in a court that in Harris County that everyone knows is very difficult to have a certain trial date. So we were able to work together and get it resolved. And it was just nice to have someone on the other side do that.
More importantly, to that case, the case in that perspective, I mean, I think y'all have been going on for like 2.5 years with no real movement. And I think we resolved it in 60 days from the time I got it until the time the case was settled, because, and I know the lawyers who had it, they're fine lawyers, but certain people just have different perspectives on stuff. And I wanted to get in and kind of sharpshoot the issues. And once I did, we got the case priced right and got it done.
It was great. It just goes to show you that don't be an asshole, and sometimes things can get done, and you can still advocate for your client.
Yeah.
And I know Chaz is still taking a little grief from it from some insurance carriers, but we worked it out.
Yeah, no, it was a good result for everybody. I think everybody's happy now. It was fun, though. I mean, this relationship game. I mean, I've got plaintiffs lawyers who sent me business. I actually got a plaintiffs lawyer called me on Friday and said, hey, one of my clients is actually being countersued. And I told them that they need to hire you, and I'm waiting to get that figured out, right? I mean, there's so many times that one of my young lawyers was freaking out because an associate at the plaintiff's shop wouldn't give him an agreement, and he had some personal stuff going on. And I picked up the phone and called their partner and said, hey, man, what's going on? Oh, absolutely. You've got the extension. No problem. I mean, act like you want to be treated. Treat yourself like you want to be treated.
Picking up the phone helps.
Picking up the phone helps. There's so many people that are keyboard warriors now, and it drives
Tommy Kirker acknowleded his keyboard warriorness.
Yeah, I do. I'm real.
So shady.
I'm real mean. I'm real mean sometimes over emails.
You can always tell. I always joke too, and sometimes people's keyboard warriors get more and more feisty, kind of as the happy hour evening goes on too. And so you can always tell when somebody's been maybe had a couple cocktails before they start sending emails.
So you have done London work. I used to do London work, and I remember sometimes I would wake up in the morning with a little bit of a please, 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 and check my sent email. I was like, yes, because that's a group that goes out late and goes out hard.
Oh, yeah.
And then when you're 6 hours ahead and you're sitting at a pub at 11, but it's 5 o'clock here, and then your response would be different if you were here also at 5 o'clock, as opposed to a lunch drink, a 3 o'clock happy hour, 4 o'clock happy hour, and a late night with boys and Lloyds.
Oh, yeah.
Then, yeah.
And that's a whole different animal over there with the London-based market. It's so fascinating how they just from one thing I did when I was at Donato Brown is I did like a 2-week, I call it internship shadowing. They call it secondment, and where I got to sit with they have claims brokers who are part of the brokerage, but not the placing side, that actually print the files and take it around to the underwriters, and they have to stamp it and handwrite it and stuff. And then got to sit with underwriters for a couple days, sat with claims handlers for a couple days, and that is way different. I mean, the thought of like over here, 99% of the time I pick up a phone and call an adjuster or call a general counsel or whatever, and then follow up with an email, right? Over there, they literally lug suitcases through the streets of London with the paper files printed and their handwriting on it, or they have these stamps and they have to have a stamp before anything can be done. It's pretty interesting.
So we have a Lloyd to London case, and if we get told like, hey, everything works a little different over there, it takes a lot of checks and balances, you're not lying.
Oh, no. And Will can probably agree to that as well.
I mean, to be honest with you, my old life, that was my favorite part of the job, is going to Lloyd's. And not because of happy hours and late night drinking and concerned emails the next morning, but the face-to-face nature of it, borrowing from conversations earlier about pick up the phone and be polite and get things done and don't be a keyboard warrior. And I'm not pointing at Tommy because I got the problem too. My problem is I got to sit back and take a deep breath so I don't fire something off I shouldn't in the emotion, is my own personal measure. But yeah, their face-to-face nature is fabulous. So when the broker talks about the risk that he placed or she placed, and the claims person's evaluating the risk, and they're talking about the plaintiff's lawyer and the venue and the risk of the case and checking the reserve and make sure the reserve doesn't need to be changed, right there is awesome. It's really cool.
That is cool. And I mean, it's cool because it's a whole different aspect than what we see.
They pride themselves on the face-to-face nature of it. And the fact that there is, when exchanging came out a decade ago and it lost some of its luster of doing coffees and talking about cases, there's boxes there for a reason, because it used to be, hey, I got a ship or I got an oil well. Will you take 10 points or 15 points on this risk as a quota share? And they'd, stamp it there in the box. So, the boxes are still there. It's just different now.
Because the way Lloyd's works is it's kind of like a conglomerate of people, right?
Yeah, Lloyd's is not an insurer.
Yeah. Certain underwriters.
Yeah.
It's like the closest thing I can compare it to is like the commodities market, like, or the stock market, right? Where it's just like people running around hair on fire, going from, you're an underwriter and you're going to take 12 points at this percentage, and Will's going to take 20 points at this percentage, and Tommy's going to take the rest, and they go around. Or maybe it's like, you know what? I don't like Omar. I want to do 50% at, 50 points at this percent just because Omar wants to do, 25% at this percentage rate,
Yeah, and mostly in the excess market, and you do excess work,
Mm-hmm.
and that's a different world than doing primary work.
Oh, yes.
Both from a monitoring standpoint, where you're kind of clientless sometimes, and then when you go try the thing.
Right.
So tell us about that.
And well, I want to break that down because we talk about that in like everyday language, but we're talking about primary insurance, meaning the first layer of insurance that goes out first on any claim paid, and then excess work is anything above that. Correct? Yeah.
Yeah, and so I think that's probably changed, and Will's probably seen it as well in the last couple of years, where probably the last 10 years, where, it used to be one lawyer for the whole case, right? And now a lot of the carriers get monitoring counsel, and I get hired on monitoring counsel roles all the time where, I'm sitting, they'll bring me in, they think, okay, this is big case, this is bad case. We want to make sure we have kind of our own independent reporting, right? Our own independent analysis and or drop you in as needed. And then certain times I'm hired by, and then you write reports, you show up at mediation, sometimes you help make a deal, help get a deal done, you participate in the process. Other times the excess carrier will say, you know what, we appreciate that primary hired Will. Will's got great socks and good jackets, but we want Chaz to come in too and co-counsel with them.
That's a hypothetical. That never happened.
Yeah, exactly.
We actually made fun of his socks earlier.
Well, that's good. But and so you come in and you actually drop in and you're co-counsel in the case. And sometimes sometimes there has to be some hard conversations where the tower says, you know what, Will, we appreciate what you've done, but we want Chaz, or Chaz, you know what, you got to take a back seat to Will. And
Yeah, it's a relationship. They trust you, and frankly, again, I'm not indicting, because I did primary work too, and I had people come and grade my papers, and it's just life. I came in as excess a lot, and it's just life. But if you got a $1 million, the money's gone the second the accident happened, versus I got a $100 million excess tower, and we know we're going to get into this layer at some point. We know the risk is there. For them to say, look, we want to hire our firm, not our firms. They don't hire firms, hire lawyers. We want to hire our lawyer to go try the case, and you get added that. And it's a weird dynamic. Because not only the politics of, hey, beat it, my seat now, which can be a problem in certain personalities, but it's also, until that leads up, you don't have a client.
Right. Yeah, you're sitting there kind of like...
Because when you try the case, it's your client.
Exactly. No, and so I try to take a monitoring counsel perspective, which has probably gotten me in trouble sometimes, but, of like, I always take the monitoring perspective of, I'm going to have to jump in here. What is the best outcome, right? Yeah. And... but on the flip side, sometimes you're sitting up there and, I've looked at a couple of them where, one time I was 25x of $1 million. So I was 25x of $100 million. Where you're the $100 million to $125 million layer, and, the damages are $1 million. That's never going to hit you under script arrest. You just you look at it, write a report. Hey, you're good. I can monitor, but, you can probably close your file at this point. So it gets some interesting perspectives and interesting dynamics. But I really enjoy the kind of jumping in with 30 to 60 days out from trial, where...
Who's giving you 60 days?
Well, that's only occasionally now. The case with Omar was about 60 days.
You don't want 60 days, because 60 days still means 30 days you can fix it.
Exactly.
The magical is 30 to trial, because it's like, hey,
well,
I can save it, or it's their fault.
Well, more recently, I had one with... there was multiple plaintiffs' firms on it, but the shortest turnaround time was, I think, 11 days back in January. Omar's partners had 2 of the fatalities, and other firms had 2 of the other fatalities. But I got called on a Friday night at dinner, and my phone was just blowing up. Same number, so I finally answered it, and it was like, hey, can you try a case in 11 days? And I said, yeah, sure, call me Monday. And then Monday comes around, I'm like, oh, okay.
I said yes to this?
This is a bigger case than I anticipated it. But, that's kind of fun at that point, because, you've got other people who are working to get you up to speed. You get to come in, you really get to dive in, you get to learn as much as you can, and you do the best you can. So, and you either get the case resolved and it's great resolution, or you go and swing for the fences, and sometimes you lose, and as anybody who's tried any amount of cases knows if you win every case you try, you're not trying enough cases, right?
So yeah, you've tried 6 cases in the last 15 months at the new firm, at least. How's that been?
Man, it's been great. I mean, my team is supportive. I've tried them with various members of my team. It's tough when you're in trial and you're out of the office. And, I like to think a lot of my trials are bigger trials. A lot of them are out of town. They're multiple days. Some of them have been multiple weeks at a time, right? And so I've got to rely on my team to work the other cases and really push those along, which they've done. And then, just tried some pretty significant big cases. In June, I tried one in Del Rio. I tried one in Henderson, which was an interesting set of facts and players involved. Last week, I tried one in Dallas. Going to go try one next week in El Paso.
Very nice.
It's been good. I've really enjoyed it, and the firm embraces. We pride ourselves on being trial lawyers, so that's what we want to do.
That's
I
great.
found the trial stuff. You call it parachute. I call it mercenary, since I switch sides. So, and I'm doing that on the plaintiff side, which is unique, I think. I find it awesome because I found, and I mentioned this to Judge Weems earlier, I'd get so committed to my report I wrote, and I'm right, my report I wrote. I always had the courage to change the analysis if the facts change. I never hid from that. It's like, hey, yeah, man, the doctor bailed on us. We're toast. We've got to pay it. So I never manipulated anything to justify an initial report so I was right. But I think subconsciously I had confirmation bias.
Yeah.
And, I thought this fact mattered and this fact mattered and this fact mattered. We tried good cases and good outcomes. But now when I'm doing it with, 4 or 5 days notice, I don't know shit about the case.
Right.
And I think like a juror because I can't get caught up in the details because I don't have time to learn the details. And the big picture stuff, presenting evidence to people that want to see the big picture is an asset.
Well, and I mean, if you think about it too, from the perspective of jury service is actually, I think, one of the coolest things that we have here in this country. You bring 40 to 80 people into a room and you're trying to whittle them down to the 12 reasonable people who are, jury of your peers. You hear the case and you don't know what they like, what they don't like, et cetera. But I will say I've tried enough cases to know that they want to keep it simple. They want to keep it short. They want to keep it direct. And, I think when you come into a case and you only have a finite period of time to get ready for it, you really have to think about, how do I whittle this down?
Yeah.
How do I explain it to these people who, look, as much as people say that they like jury service, no one wants to get picked. It's an inconvenience, right? They just want to show up because they're told they have to be there. But, but I will say that I think that every jury case I've tried, I think that the juries inherently, for the most part, get it right. I think that there's a reason why we have the jury system, and I think it's a great system. And obviously, sometimes juries go haywire and somebody was seeing something wrong, but I think they inherently get it right most of the time. But I do think that they want it simple, they want it short. I try to keep opening statements to 10 to 15 minutes max. I like to keep cross-examinations under 30 minutes. I like to keep direct examinations, 20 minutes or less.
Don't be the one wasting their time. Let the other side do that.
No one wants wasting time. Now, I will say, after watching Shane's video, Shane said he's a paper guy. I'm a huge tech guy. I think tech is so important to keeping the jury's attention. I think so many people, my wife says this all the time, she's a visual learner. She's a visual learner. She needs to see something. And I think when you're trying to explain complicated concepts in a simple way, the easiest way to do it is to show photos, show videos, show records, and use tech. I mean,
it breaks it up too. I mean, it makes it not so monotonous of going through that way.
Yeah, I mean, the case I tried in Dallas last week or the week prior, young plaintiff's lawyer, had been practicing about 3 years, maybe 4 years, his third or fourth trial. He did a great job for the facts that he had with him, but he didn't show a single photograph of the accident. He didn't show a single medical record because he didn't have any of the tech. And, he also didn't have the facts and the records to support it. So I understand why he
strategically
didn't
avoiding
show those. But, I think that it's important to break it up for the jury. There's this book that I got in law school, and I actually read it every year. It's a guy who was a trial lawyer in Chicago in the 50s, 60s, and 70s. And I think he said he tried like 2,500 cases in 30 years or something,
Jeez.
right? And I actually read the book every January because I always pick up something different. It's like he decided to retire and just write all his crazy war stories down. I know that Will and I, when Will's on the defense side, there's probably some on our side of the bar that could write similar books with great stories and whatnot. But he has a whole chapter on why you need tech and why you need to videotape stuff and why you need to show it. Because I think his mindset was there's like the average person's attention span's 20 minutes. And so after 20 minutes, you need to change it up. You need to do something. And I try to keep that mindset when I'm trying the cases, especially when I'm trying to refine down sometimes 4, 5, 6 years of litigation into 14 days, 20 days before trial. You've got to simplify it.
Yeah. Do you have a paralegal that knows how to handle a parachute case? Because they're not the same.
No, I do. Currently I have 5 paralegals, and I have them, I have construction paralegals. I have, my kind of run-of-the-mill, move the case day-to-day paralegals, and I have a parachute-in paralegal. And the parachute-in paralegal is actually a lawyer who decided didn't want to do the trial work anymore. She wanted just paralegal work, and I'm not demeaning that. Just didn't want to argue in court and whatnot. And it's fantastic, but it is a totally different mindset from filing an answer instead of like jumping in. I mean,
so they're trained on the uniqueness of that.
Yes, I train, my people are trained, and I have lawyers too that I know which lawyers fit into which roles. I mean, the parachuting into cases is not for everybody. It's stressful, it's late nights, it's writing reports, and some people hair is on fire because this witness testified to this and testified to that, but the report kind of paints it as a rosy picture. Like, well, hey, it is what it is. We don't make this up. We just get it as it is. Yeah. And there's only so much we can do at that point.
Well, the case you came in with our firm 11 days before, I mean, that was a very scientific based liability aspect. And so how was that?
So that was tough. I mean, Luckily the firm we were coming in with, we came in as co-counsel. We didn't come in as replacement counsel. So they had some very, engineering heavy associates running with it. And so I had kind of in-house experts to help get me up to speed on those issues. But also, you also have to, as I was talking about earlier, delegate, divide the workload, figure out what is your strength versus not your strength. If there's that case involves like very technical construction engineering and welding and stuff. Some of it just like Tommy was the guy who took all 4 of the depositions on those issues. He needs to just handle that because it's just too much to learn. You'd be doing a disservice to the client.
So that's part of the role when you come in is kind of manage.
Oh yeah, you're kind of like the quarterback or the general of the team, and I really try to make trial work as a team sport. I want to delegate to the associates. I want to delegate to the partners, and I think it's important to look. If it's a car wreck case, 2-witness car wreck case, I can go try that by myself all day, every day. But it's, case next week is, I think there's 32 witnesses. I mean, you cannot prepare to adequately defend your client with that many witnesses and cramming. And also sometimes it's good to just take a breath because, trial is exhausting. Trial is my favorite thing in the world, except maybe coaching my kids' sports. But trial is my absolute favorite thing. But at the end of the day, you're exhausted. And if you don't have a second to breathe so that, hey, here's this smaller witness, I can then prep for their expert, you'll go crazy.
Even being a 2-3 day trial, it's a lot of work. You're nonstop from the morning to night and just the trial, and then you got to prep for the next day.
It's the brain drain.
Yeah.
Your brain is committed to the activity regardless what you're doing.
And then you're just, to do 6 of them in 15 months is, not many people can do that. Not many people do that.
Yeah, my most was 12 in 12 months, and that was in 2022, and that was an exhausting experience. Of those 12, only 2 were in Houston, so the rest were traveling.
So your wife is pretty understanding as well?
I couldn't do this without her and her support and my kiddos' support too. Yeah. But I try to incorporate my kiddos into as much things as I can. I talk about them in voir dire. I relate to the jury in voir dire with them. Certain days I wear my kids' faces on my socks during trials. So, and then the work-life balance after. If you can't do trial work, if you don't have a balance, you've got to be able to do something else as well. Otherwise, you just get all consumed. I love it to death, but I also love coaching Little League. I love coaching football. I love going to my daughter's gymnastics. And that's the other thing I tell the young lawyers is make sure you have a hobby. I don't care what it is, but you'll go crazy if you don't have a hobby.
Average size case, $5 million at risk, $2 million at risk, $3 million at risk, something like that. Not, low sevens, not eights. Is it you, a trial paralegal and associate, you, trial paralegal, associate partner? Like, how do you team that up?
So the case like that, depending on the client, sometimes it's client driven, right? Like if I have a partner that is, the client really likes and wants to service, it'll be me, that partner, associate, trial paralegal. If not, if it's more of just a run of the mill, low 7-figure case, it's me, associate, trial paralegal.
And your associate takes witnesses?
Yes. I will let.
Will you take an associate to trial if they won't take a witness? Or are you saying you're coming, you got to participate?
Yeah, so if an associate's coming, they have to do something. And what I do is about 2 weeks out from trial, I make them come up with what their ideal split of the trial would be. And they go through it and they kind of make the script, right? Like, here are the 5 witnesses they're calling, the 5 witnesses we're calling, and here's how I would divide it up. Sometimes I agree, sometimes I disagree, and I say, no, I appreciate that, but this is probably not the case for you to take 3 experts and me take 1, right?
It's the lead liability witness, where it all comes down
yes,
to
or other times I'm going to say, wait a
yeah.
second, you're not doing just the damages, guys. We're going to swap this up.
Do you let them open?
I have in the past. So the one thing about me
I
with
shouldn't say let them. That's probably not fair, but in that scenario, it's let them.
yes, I mean I also defer to the client though too. Like I had a case, one of the ones I recently parachuted into, the client was like, we hired you, you were doing everything, and so
Who's the client? The insurance company or the actual named defendant?
So always the client's named defendant. There's no question about that. But, obviously the relationship with the insurance companies, that's how, well, honestly, and the direct hire. I mean, a lot of my clients, though, are also just direct hires where they have either high self-insured retentions or they have choice of counsel or something of that nature. But, I will typically let an associate or a partner do as much as they want without it being detrimental to the client. But I also...
Client benefits from mixing it up.
Correct.
If they hear you the whole time, because I like the personality of jurors going to know when I'm taking a witness, because they're going to know when I stand up what that witness means, because it's Will's witness.
Sure.
And I don't want to have that for a sweet lady or a moaner groaner or a doctor that's not in real, controversy.
Yeah.
And I think navigating those personalities with the role of the lawyer team matters. And I think a client's making a huge mistake if they say, will you do everything?
Yeah, I mean, sometimes it just has to be that way just because of the nature of the case and so forth. But, I agree. I mean, I think it's better for the team. It's better for the client to divide it up. I think it lends credibility when you're doing certain things. And again, I think you're just sharper when you've had a second to just sit back and let somebody do it. I mean, I truly do.
Yeah. And so I know we kind of went over a couple of things beforehand, but when working up the case on the defense side, obviously the plaintiffs are asking for some monetary amount. Most of us have to go to mediation before. What can we do on the plaintiff side to make mediation more effective or efficient, or what do you need to see from us?
And you can't say make reasonable demands, because that's not going to happen, sir.
They are reasonable, first of all.
Yeah. Whoa.
Will.
Yeah.
So, I think that's kind of a double-edged sword, right? Because I think on my side too, by my side, I'm talking about the defense side, because I'm going to give an example, but like I went to a mediation yesterday and we started the mediation with Norman Roser, who I love dearly, and he's, part-time mediator, full-time comedian, right? And he comes in, he says, hey, man, I'm just going to tell you, they just told me they're deciding to add a $45,000 wage claim the morning of mediation, right? That doesn't help. I mean, it's new information the day before mediation. It just doesn't help. So, I mean, I think, just making sure the T's are crossed and the I's are dotted beforehand, making sure we have all the records. I mean, look, I get sometimes a bill slips through the crack, but I've been at some lately where $200,000 worth of bills show up the day of mediation.
We're surgical wreck.
Yeah,
First
exactly.
time.
Surgical wreck. You're hearing for the first time mediation. Or, they're maybe making a traumatic brain injury. Now, I get on the defense side. Sometimes the defense lawyers don't do their homework and they're like, oh, well, we thought there was only $1 million in coverage, but there's really a $10 million excess policy. So again, it's just like, and I get it, everyone's busy, everyone, has a lot going on, and but just making sure that, sloppy mistakes, right? I get sometimes people disagree on the value of the case. That's why we go to trial. That's why we go to mediation. And you may go to mediation and just be like, this happened today. The plaintiff's lawyer was like, I think you're wrong. One of my associates, I was kind of listening in on his mediation, kind of grading his paperwork, right? And finally, he and the mediator and the other lawyer went into a Zoom room together and said, he's like, look, man, I get everything you're saying. It was Peter Taves, the mediator, who said, y'all's pre-mediation reports to me, memos to me, were identical. The medical summaries matched, the medical damages matched, but they just completely disagree, and that's okay. But at least going in with the information on point, and making sure the information was the same, to quote one of y'all's competitors, Bill Ogden, he says that, look, if you're arguing facts at a mediation after 10 a.m.
He stole my line.
Well, he said it, and he claims he owns it. So, but he said that, and I'm like, I agree. I mean, look, if you're starting a mediation to fight over facts for more than 20, 30 minutes, it's just a waste of time. I mean, it really is.
It seems like the first mediation, it's not a waste of time. It's a good stepping stone but it seems like these high risk cases need 2 or 3 mediations. They need to be close to trial dates, and it's almost like getting ready to get to trial, but to mediate.
Well, his client's insurer has posted a reserve based on what he has written or his colleagues have written in a report and an evaluation. What are you doing as a plaintiff's lawyer to make sure his client's insurer knows your position in the case?
Yeah, you're taking depositions, making sure the case is all ready to go.
Or send a demand.
Send a demand. We always
That's
send a demand.
That's not just
30
bravado
days before.
And chest beating and I've written. See if you like this idea. I wrote a demand in a recent case where I said, I don't know where to start. I'll start here. This is your defense report, and this is what you're being told by defense counsel because I wrote 10,000 of these things. This is where we agree to, and this is where you're wrong, or we think you're wrong, respectfully. And I thought it was pretty cool because it's like, no, you now have an obligation to send this to your client, your client's insurer, and they need to know that, outside of a little bit of discovery that maybe is reported on, this is what we think you're missing. Maybe you are, maybe you're not. We don't know. But that's the whole thing.
And that's the benefit of coming two sides. Like, I don't know what a defense report looks like.
Yeah. What you get to mediation built on a reserve recommendation or a reserve position built on the risk assessment presented in a litigation report written by defense counsel. That's what it is. Okay. And I don't have any problem when he's writing them. But there's some people in town I don't trust when they write them because they're business advocates. They're not representing their client.
Yeah, I mean, I think there's lately too been a push to an early mediation on things, right, where things aren't fleshed out. You get the truth in my reports. I don't sugarcoat things in the reports. If it's a bad witness, it's a bad witness. Now, unfortunately, a lot of my cases that I'm in now it's not a do you win or lose, or a win or loss is defined by how much you pay on the case. It's not defined by how much, are you going to win on liability or not. And so, but, making sure that the reports are done properly. Look, my job is to get the best result for my client, whether that be a settlement at mediation, a settlement before a trial, or go to trial in the case. That is the best result possible, and I'm just trying to get it. And my job is to defend the case and get the information so the client and the decision maker, because sometimes it's general counsels and in-house CFOs because of an SIR, or because it's it's just a business case, or their insurance tower. They just need the information to make the decision. I don't make the facts, and I think unfortunately, I'm trying to train up the younger lawyers. Like, we don't make the facts. We weren't there at the time these cases happened. We weren't there at the time that so and so hired a guy who had just gotten his license suspended for being in the pen for selling meth. Right? I mean, like, that's not a fact that we make. That's a fact that should be reported on. I mean, and it influences the case. So, just making sure they're reporting. And, I'll also say, from my perspective, what helps is like what Will's saying from a perspective of writing demands, like put the actual stuff in the demand that is pertinent to what's it called. I get so many demands where it's just like, oh, your lawyer's terrible. Oh, this prior lawyer was terrible. We couldn't get along, or he doesn't understand the value. Okay, well, tell me how I don't understand the value. Tell me why, so I can tell the decision makers. I mean, so we can make a reasoned decision on the case.
Chaz made me start putting the number on the first page.
Yeah.
He was like, I don't want to flip through. He's like, the first thing I look for is a
Chaz does what I did is court, venue, plaintiff's lawyer number. And from those 4 things, I can assess the case more often than not.
Yeah. I mean, it really is. And it's, I mean, the problem I have is I go back to what we were saying earlier. Pick up the phone and talk to people. Be nice to people, and you can pretty much work it all out. And just, understand that both sides have to compromise. That's how you get a good settlement. I mean, and
no. That's good to know. I mean, it's a shame that we're always considered adversaries, but we're trying to get to the same result, and no one's going to try cases for fun.
Right.
You have the client's livelihood at hand. So the best result sometimes may be trial, but you got to go from there.
Getting the client motivated to settle the case, the defense client, is a key to getting the case settled too. Because if the client starts raising hell with the broker, and the broker is going to the insurer or the insurance tower to say, settle this case and here's why, that's a huge asset to your ability to settle the case.
Yeah, absolutely. I mean, it's writing those demands. I know Will's taught me a lot too. There's certain language you need to put in there to get them motivated and let them know, like, this is where you are. But one thing I've been trying to do, because all the good mediators, we've mediated with Chris Volf in our case, and you can't get him till 2026. But I've started asking defense counsel now early on, like, who do you like to mediate with? Let's just book one 8 months down the road.
That's smart.
And then let's have a deadline. I don't know. Does your side see that as a weakness or not?
No, I mean, look, and this is not to toot my own horn, but I'm so busy. I need it, right? Because if we get to the point where we've litigated for 8 months and then it's time to get a mediation set, you're probably looking at another 6 or 8 months before I can fit something in with another good mediator. And look, it's kind of primacy and recency, right? Like, whatever's right there in front of me is what I'm focused on. But if I know 8 months from now, Omar's got this case and he claims it's a big case, I mean, that keeps everyone honest. Yeah. Yeah, y'all say that, don't you? But that keeps you honest and working towards a resolution. And you know what? Maybe 6 months down the road, you say, you know what, Chaz, we got to call Chris and bump it another 3 or 6 months because we're just not ready yet, right? I mean, we want to make with the size cases that all of us handle, you want to make sure it's developed appropriately to go to mediation.
Exactly, and so that's kind of been the new thing, because we have great mediators that are available, but almost every good mediator is not available anymore. And if you want to make it worthwhile, you got to have a good one that can talk to the insurance company, that can talk to a client and talk to us pretty much, and kind of go from there. But I'm glad you guys don't see that as any sign of weakness, because it's just trying to move our side along.
No, I wish more people would do it, because then you've run into a trap of, oh, shoot, the court's got a mediation deadline in 30 days. What are we going to do?
Yeah, it's court ordered in Houston almost universally anyway. And the other pet peeve I have now that I will admit I didn't embrace as well as I should have is production of the tower. Who cares? But you'd have some underwriters say, well, you can't give the third excess up because you're going to send a message to the plaintiff's lawyer, you think the case is valued at that. Just produce the insurance policies and produce the whole insurance policies, right?
Let them try to read them.
Yeah, not big of a deal.
You should see a plaintiff's lawyer try to read an insurance tower.
It's pretty funny.
It's comical.
What does 5 mil PO 20 mean?
Yeah,
it's 5 million part of 20. It's a quota share. I don't know what any of that means. I'm going to send it to you.
Yeah. I mean, it's fun to try to do, and you're like, all right, who's here at the mediation? Can I figure it out? I'm like, I don't know.
I tell you one that I will give it, not a secret. It's no surprise. I find out who's at mediation. If I know Chaz is involved in excess, if he's got one of his excess clients there, I want him there for 2 reasons. Either I think I can get money out of that layer if the case supports it. And if the case doesn't support it, he becomes an asset to me to settle the layer beneath him.
Yeah.
Because he can start raising hell about settle this case, because I'm protected when you get it below my attachment and you buy a release for that and I'm clean. He becomes an ally. And that's some of the plaintiffs' bar just doesn't see well on the excess play of where your allies lie. And it's a meaningful deal. And sometimes insurers get all bitter about, oh, well, you're setting intra-tower competition. It's like, well, the second you lose, you're going to sue them for equitable sub-row anyway.
Oh, yeah.
It's not like you're holding hands in this deal. So if you promise never to sue them for equitable sub-row, I won't send a canal letter.
The insurance industry is so complicated. There are so many moving parts, or there are so many moving parts, and trying to explain it to a plaintiff as to why demands are made where they are, that's really hard on our side. So
Well, and I can imagine it's really hard on y'all's side too. When let's say that let's say the case is worth $2 million, right? But you got to start for mediation purposes, right? You got to start at $12 million or $9.8 million, right? And then it's like, well, each time you're going down, right? And so the defense side may be going up in smaller increments to get there, right? I can only imagine how difficult that is to explain to somebody who's heard you. Well, why'd you say it was worth 9.8 and now you're saying it's worth 2, right?
You can say it and they won't. And this isn't an indictment on clients, but it's the reality of once you hear it, you can't unhear it. It's a bell that's rung, and they hear 9, and then you tell them, look, this is demand, this is fantasy land. I could be asking for unicorns and leprechauns. It's the same effect in the other room right now. It doesn't matter because it lingers. Bert Plyman's a mediator in Austin, and he's got a bracket philosophy that's just a shade below, and it's really tight and doesn't do these big things because he didn't want to hear someone say 10, 2, 12, 6 is the midpoint. He'd rather you go, no, make it 7.5. I mean, literally don't get so high up. Make it just a shade under.
Right.
Because he thinks the subconscious of the plaintiffs hearing that is deleterious to a settlement.
Oh yeah, I can only imagine look, all parties in these litigation things have difficulties, right? We're dealing with our side, y'all are dealing with your side. It's just part of it. But I can only imagine the kind of human side aspect of it. Because look, I hear it all the time that no amount of money. All we can do in our civil thing is to award money, right? But they really want to go back to being pain free and stuff. But obviously there are the cases where somebody is not in pain and they're, just trying to get it. But I think a lot of them, they would rather have their leg back. They'd rather have their arm back. They would rather have whatever. Yeah. So there's sometimes the worst case I ever tried was 2 high school friends. They graduated. They were now in college. They were in a drunk driving accident, a horrific drunk driving accident. He killed his best friend. And it was 2 families who were friends. They then started obviously fighting and so forth. And, the verdict was a fantastic defense verdict and so forth. But there was no solace to my kid because he killed his best friend. He was always going to know that, right? And the plaintiffs, there was going to be no matter what happened, there was no bringing their son back, right? So there's a human side of this job too that you can't forget about.
It's hard, and that's hard. Sometimes, when you're in lawyer mode, you kind of have to sit back for a second and say, you're dealing with something that I have to always have that speech of, I promise you, I do care, but right now I'm having to focus on this. But don't take it, it doesn't take away from the fact that I'm here to represent you. And it is hard because sometimes you just get in that mode because we see death.
Yeah,
constantly.
Always, it's tough. I can only imagine. I would not. Sometimes we see stuff that we get desensitized to because it's just part of our job, right? And our job is to advocate no matter what it is. But sometimes you run into those issues, and it's a tough pill to swallow. Even if you pour, from my side, you pour somebody out who's hurt, but there was no liability, right? They're still hurt. They're still in pain. But
yeah, have you run into a plaintiff that you really like, and you're like, oh man, it's like we don't need to try this case. He or she deserves some money.
So I've had cases where I have said that the plaintiff's likability factor is going to potentially outweigh any liability defenses that we have. I had one case one time in Beaumont where I said that the spouse's consortium claim was actually more valuable than the injured plaintiff's claim because she was such a better witness than he was, and we paid, she got paid more than he got paid. But that
from a jury on settlement.
Settlement, yeah. But I was writing it up saying, look, if we go to a jury, they're going to hate the plaintiff, they're going to hate her, but she is such an awesome witness. They may give him money even though he was 100% at fault. That factors in. Those are the. Look, I argue.
Risk. No one knows.
You never know.
But that's the problem when you see that. But yeah, you can have, and I wrote and had conversations with insurers like, we're going to win liability every day, all day. I'm like, it's not bifurcated, brother.
Right.
I said, Exhibit A is the plaintiff sitting in that wheelchair for 2.5 weeks, getting wheeled in and wheeled out. And if the jury decides from a nullification concept, I'm going to find a way to make them get money. Guess what? You just took a yes on liability and a comparative fault them somehow, and they're going to pay them. Like, it's not in a vacuum.
The
And I
jury
think-
gets that when you start reading the
yeah,
questions
and they're not
together.
supposed to, and I get that, but you can't just completely wash away the emotion in some cases. And I think I made a mistake when I was evaluating coin flip liability cases and not paying enough attention how damages affect the liability, because they do.
Oh yeah. Or, I mean, in essence too, I mean, like when you deal with aggravating fact case, you got a drunk driver, but no real damages, right? That can that can flip side too. They can be so mad it bumps up the damages.
Yeah.
I mean, that's why you got to look at the whole. There's no science. It's not a science to it. It's not a check the box thing. The good defense lawyers, in my opinion, Will was one of them. We run in a circle of good ones. You have to look at the case in its entirety and how you evaluate it. There's no if this, then pay that. No, you have to look at everything. You have to look at the witnesses. You have to look at the evidence. You've got to look at the court, the judge, the jury, and come up with that number. And, it's important to look at all of that.
Yeah, I agree.
And in mediation, going back, openings are stupid. Don't do it.
Oh yeah, no, I don't think anyone does it.
But as a defense lawyer, didn't you want to, not want to do them, but in the position if a plaintiff wants to do it, go ahead, because if you're going to give me your opening statement now, I'm taking good notes.
So the problem is, in my opinion, is it just I mean, yes, there is that mindset, but now so many times, like, I'll just turn my Zoom on black, like, because so many mediations are on Zoom, even on the big cases. It used to always be in person. But I mean, it tends to just work to irritate somebody, especially when it's it irritates the client, right? The general counsel, the risk manager, whatever, who it just happens. And so I think I'm fine with a meet and greet. I think go in, say hi, whatever. But what I've started doing is I actually make a PowerPoint with depot clips, depot offers, what I think is, what I want the mediator to know. And I'm trying to teach my team to do this, but get it to the mediator like a good 3-4 days ahead of time. And they say they look at them and they say it's helpful. I mean,
Our mediators do.
I think that is.
Yeah, these busy ones do.
Yeah. So. But I think it's helpful. I mean, give it to them and let them be the advocate.
I've sent my mediation statement to defense counsel on a couple of recent cases under 408 and saying, hey, this is what I'm telling the mediator. Make sure your insurer knows what I'm telling the mediator. Go nuts.
Yeah.
No secrets.
My point is, like, there's nothing.
Which no one does that. Y'all don't do that. No one does that.
No, we just send our demand.
Yeah.
I'd be happy. I mean, like, my report, I try to think that my reporting is objective. And, I've got no problem. And I think I have the reputation of it that I just tell the truth in the reports.
You're not the problem, sir.
I know, but I'm just saying, like,
because you will price the poker game the right way. But there's colleagues of yours in town who are such a committed business relationship with their insurer, they're never going to be freaking honest with them.
Sure.
Ever until it's too late. And by then, the clients are so. What do we got to do in a mediation if fellas? Go spend $500,000 in a case to get ready for trial before someone gets shaky-kneed and says, well, let's settle the case. Well, you just cost my client $500,000 of their money. Right. Because y'all didn't have a case assessed the right way. Not you, but folks that are too committed to I got to do what the insurer wants.
Yeah.
I run my reports in the way of, like, if I left the file there, I really have no problem with you picking it up and seeing, because it's going to be objectively, you may find some typos, or you might not like my font. Apparently my associates get mad at me because I still double space after a period.
I still do too.
You're allowed. You're a particular vintage.
They tell me that I'm now old. When I was in trial in Henderson, we took a summer associate with us, and which I thought was awesome. He's out of town. The firm said, we think this is such a good.
Nothing will say take a job at Weinberg Wheeler like going to Henderson for some pie.
Yeah. Well, so go to Henderson on this
Carthage too, if you're crazy.
On this mega case. It was one of the most interesting cases I've ever had in my career. We take her up there, and I'm like, you're not a spectator. You're going to be in the war room at night. You're going to be in the war room. You're going to contributing. I want you to, any feedback you have. You're going to be in the counsel room.
She's a juror. It's perfect.
Exactly. So we were kind of at the end of every trial night. I always jammed music, and I joke and say, name that tune, because the associates are so young, so much younger now, and my music choices are way old.
Do you have walk-up music you listen to before you pick a jury?
Yes, I do.
Nice.
But so I'm playing a tune one night, and I was like, man, I remember when I was in college and this came out. And she goes, I was in 4th grade. I said, everyone get out. I'm going to bed. I was like, man, I'm so old.
What's your walk-up song before you pick a jury?
I can't tell you that. I'll tell you that off the record.
What is it? What's yours?
I don't have one.
You don't have one? That's a huge mistake.
It used to be Chop Suey. that old System of a Down song.
Yeah.
But I'd had that from high school too. Whatever, it just gets you so pumped up.
I have a loop of 3 that I just play on repeat for about 30 minutes before, and but I can't give out the secret sauce on everything.
No.
The Al Pacino Inches speech is pretty good too from Any Given Sunday. If you haven't heard of that, that'll get you.
Mine's Seek and Destroy on Kill 'Em All by Metallica, to be honest with you.
I love it. I love it. Now I know his secret sauce.
There you go.
Yeah.
Well, Chaz, well, thank you, man, for being on here.
Thank you guys for
This was
having me.
great.
I'd love to come back. So,
Yeah,
yeah, wish you all the best of luck.
thank you.
Awesome.
All right.